if you're all wondering about why and who and what happened, why was the Emergency Act overthrown, or, well, not overthrown, but deemed as unconstitutional, then we have Christine Van Dyn interview that I managed to capture today. Now, she represents the Canadian Constitution Foundation. She is the person who pushed the courts to reopen and look into the Freedom Convoy and the unconstitutional use of the Emergency Act. And I managed to just get some clips of her on the radio as I was driving to work this morning. It's while I'm driving, but I just thought I'd like to share it with you guys, because I've not heard this anywhere before. I've not heard her speak or actually discuss what they were talking about before. So we're going to start off with what she was saying about why they went for the litigation and why they looked into it again. Obviously, we know the reason, but why their reason was. And then we're going to move on further on nearer to the end of the video. She'll try and talk about what people can do now that this has been pushed through. What chances Freeland got of fighting this, and yeah, just a really interesting interview. Let's just kick it off.
I can't overstate how important that is, that we don't use emergency legislation to shut down protests.
As you can see, what I captured was while I was driving, but it's really worth listening and trying to listen to what she's got to say on this matter. Now, at this point, they were asking her that the Emergency Act had been changed previously, and there must be frustration about how it's been enacted again after it was changed previously.
He's absolutely right. The rewrite of the Emergencies Act was replacing the War Measures Act, which most Canadians know was a piece of legislation that had been badly abused by previous governments. It was used to intern Japanese Canadians. It was used during the October crisis, the FOQ crisis, which, to be frank, that was a real crisis. But the implications of using the Emergencies Act, the War Measures Act in that case, it went too far.
Yeah, but previously, when the War Measures Act was introduced, there wasn't bouncy castles, and they weren't cooking barbecue for homeless people. There was a person actually killed during that time.
Yeah, there was a targeted assassination of a federal cabinet minister, and it was unknown how many hardened terrorist cells were operating in Canada. So it really was a dangerous situation. You compare that to this case, where the finding of fact by the federal court was that the only potential for violence during this protest was in Coutts. And in Coutts, Alberta, where arrests were made using the criminal code by the RCMP. No special powers were needed. And that incident, which was the only threat of serious violence, it was resolved as the Emergencies Act was being declared. And one of the parts of the threshold of invoking an emergency is that you can't address a situation with existing law. Right. And clearly existing law was used to address the most serious part of the protest.
As we all know, Christine Freeland has already come out and said, within minutes, that they're going to appeal this. How will the foundation deal with it? And what chance has Christine Freeland and Justin Trudeau got of winning an appeal?
So my immediate response is bring it on. This is a extremely detailed and well-reasoned decision, and includes findings of fact, like that one that I just mentioned about the only specific example of a threat of serious violence was in Coutts. That's a finding of fact that is incredibly difficult to set aside. So what the government will need to do is show that there's an error in law. And given the extensiveness of these reasons, I think they're going to have a challenge with that. And the other thing is they seem to be really emphasizing this strange interpretation of the Emergencies Act. Christine Freeland mentioned it yesterday again, this notion that the term, which is a defined term in the Emergencies Act, threat to the security of Canada, Christine Freeland sort of suggests that it has a myriad of meanings, including economic harm, and she said that again yesterday. And this is just not true. Economic harm, well, of course, serious. We don't want economic harm to our country, but it does not constitute a threat to the security of Canada in the terms that set out in the Emergencies Act. The statute has clear definitions, and if you just think through what it would mean to say that a threat of economic harm is a threat to the security of Canada, that would mean labor disruptions or strikes
Right.
could cause the invocation of the Emergencies Act, something I think all of us would find highly troubling, and it's clearly not what was meant here. The legislation had very clear definitions imported into it from the CSIS Act, and the law says what it says, and whatever Christine Freeland wants to believe, it just doesn't change the fact that the words are what they are in the statute.
It does make you wonder if breaking charter rights in this situation could bring on a class action lawsuit. Now, people have been prosecuted in Canada for and persecuted and dragged through the mill for much less than this, just for saying things, you know, like the men and women argument and all things like that. All that is like all blows up out of proportion. This is massive. This should be a class action lawsuit against the government.
So I'm not an expert in this area, but the general principle is that you can sue for unconstitutional executive action. So, you know, police brutality is a classic example. The regulations under the Emergencies Act were executive. These were regulations created by cabinet, and they were found to be charter violations. Specifically with reference to the bank accounts, it was a violation of the right to be free from unreasonable search and seizure, because your banking information is about, you know, it goes to your biographical core. It tells people if the government sees what's in your bank account, they know about your financial socioeconomic status. They will know about your lifestyle choices. It's very personal information. I mean, frankly, I don't want my husband looking at my credit card statement, let alone the government. So that's a privacy violation. But there's also this actual cost associated with having your bank account frozen. So if someone, for example, it compromised a business loan, you know, and you lost your business because you were not able to make payments on your business loan because your bank account was frozen. That's a real intangible damage. So, I mean, look, I'm not an expert in this area. We don't do that type of litigation at my organization, but I can see this case being made out. But to be successful, what you really need to show is actual damages, and you need to make sure that your legal costs of bringing the claim would exceed whatever your payout would be. So I think you'd have to have a pretty severe case in order to make it worth bringing a claim. Having your account frozen for a few days and having a privacy violation, while sure you could sue, you might not recoup more than you spend to bring the claim.